Welcome to LexiCast, a podcast designed to help you grow in your legal practice, with weekly updates on current topics, trends, and practical insights. Perfect for listening on the go. Let's dive in. So I want to start with something that genuinely doesn't add up. In the same fortnight, AI was formally banned from a legal dispute by a tribunal and used to beat an experienced legal team and a barrister in a completely different one.
Hang on, banned in one and winning in another? Same 2 weeks?
Same 2 weeks, same technology. And today, we're not going to pretend that's simple, because it isn't. We're doing both sides, where AI is genuinely making workplace disputes worse and where it's genuinely making them better, sometimes in the same jurisdiction.
Okay, I need specifics, because right now, those sound like they can't both be true.
They're both true. A Fair Work Commission member ordered two parties in a live dispute to never use AI to write to each other again. A workplace lawyer is publicly calling for financial penalties against self-represented people who use AI to run their own claims. And then, this is the one that'll actually surprise you. A self-represented academic used AI to beat his university's own legal team, including a barrister, in a landmark decision.
Wait, someone actually won using AI against real lawyers?
Against real lawyers. So that's today's episode. Genuinely, both sides. Why AI is a real risk in a live dispute right now, and why, done properly, it might already be outperforming people who went to law school for this.
Let's start with the ban, because I want to know how a tribunal gets to no AI, full stop, as a remedy.
So the background is a bullying complaint. A caretaker working for a body corporate at a residential complex in Queensland applied to the tribunal claiming the committee had been bullying her. The tribunal member agreed there had been bullying, so that part's not really the story.
Right, that's a fairly standard stop bullying application.
Standard application, unusual order. Because when it came to fixing the ongoing relationship, because these people still have to deal with each other, the member looked at the correspondence being sent on the applicant's behalf and was pretty blunt about it. Said it was lengthy, repetitive, full of sweeping generalisations and written in an accusatory tone. And the clear inference was, this reads like it came out of an AI tool, not a person choosing their words.
And that mattered because?
Because the tribunal's job in a stop bullying case isn't just who was right, it's how do we stop this happening again? And the member's reasoning was essentially, this kind of correspondence isn't just unhelpful, it's actively making the relationship worse. It's making the other side less likely to engage constructively, which defeats the whole purpose of the process.
So it's not AI bad in the abstract. It's this particular AI-generated correspondence was making a bad relationship worse.
Exactly. And the order reflects that. The tribunal made several orders to stop the bullying, and one of them said, in effect, all future communication between the parties must be accurate and respectful. There's to be no use of AI tools in preparing that correspondence, and communications should be kept brief and responsive rather than sprawling.
Okay, I have so many questions. Starting with, how on earth do you police that? Do they hand it over to an AI detector? Ask them to sign a statutory declaration every time they send an email?
And that's the exact reaction a lot of practitioners had when this order did the rounds. There's no stated enforcement mechanism. It's not like the tribunal has an AI sniffing device sitting in the registry.
So is it actually enforceable, or is it more of a strongly worded expectation?
It's a formal order, so a breach could theoretically be raised again if the bullying resumes and the correspondence looks the same as before. But you're right that proving this was written by AI isn't straightforward, especially now that plenty of ordinary word processors have built-in AI assistants you might not even notice you're using.
Right, that's the bit that worries me. If I use the grammar check suggestion in my email client, have I technically breached that order?
Probably not what the tribunal had in mind, but it does show how blunt an instrument no AI is as an order. The intent is clearly about substance. Stop sending sprawling, accusatory, AI-flavoured essays and start writing like a person who actually wants to resolve the dispute. But as drafted, it's a genuinely hard thing to comply with, let alone enforce.
Can I push on that a bit more though? Because brief and to the point sounds simple, but for a lot of people in a bullying dispute, brevity is genuinely hard. When you're upset, you want to explain everything, every incident, every bit of context.
That's a completely fair point. And a few commentators made exactly that observation when this order came out, that keep it brief might actually be the harder instruction to follow than don't use AI. Because, ironically, the reason people reach for AI tools in the first place is often to help them organise a flood of frustration into something coherent. The tribunal's order removes the tool without necessarily solving the underlying problem, which is that the person still has a lot they feel needs to be said.
So is there a version of this where AI actually helps rather than making things worse?
I think that's the more interesting question the case raises, even though the tribunal didn't really engage with it. There's a real difference between someone using AI to vent 40 accusatory paragraphs and hitting send versus someone using it to structure their thoughts and then a human, them or a support person, actually editing it down to something respectful and proportionate. The tribunal's order draws the line at no AI, full stop. But the actual problem it's responding to is unedited, unfiltered AI output going straight out the door.
Which is a distinction that's easy to lose if all you take from this is AI equals bad.
Right, and that's worth remembering before we move to Flashpoint 2, because the same distinction matters there as well.
So what's the actual takeaway here for someone advising a client through a workplace dispute?
I'll get to the practical takeaways properly in a minute, but the headline point is this. How a client communicates during a live dispute isn't just a tactical or persuasion question anymore. It's now something a tribunal can and will make an order about. If your client, or someone drafting on their behalf, is leaning heavily on AI to produce correspondence, that's a live risk, not just a style problem.
Okay, let's talk about Flashpoint 2, because you said this one's spicier.
So separately, a workplace lawyer who does a lot of defence-side work, acting for employers, put out some numbers publicly. General protections claims are up around 150% over the last 3 years, and self-represented applicants in that space are up around 200% over the same period.
That's a huge jump. What's driving it?
His argument is that AI has removed the friction of filing a claim. It used to be that if you wanted to run a workplace claim without a lawyer, you had to figure out the forms, the legal tests, the language yourself, which was a real barrier. Now you can describe your situation to a chatbot and get something that looks like a legal document in minutes.
Which sounds like a good thing on the surface. More access to justice, right?
That's exactly the tension he's pointing at. His view, from the defense side, is that it's not really increasing access to good outcomes, it's increasing volume. He says almost every second matter he's now handling involves a self-represented person using a chatbot as their legal advisor. And he's got over a dozen trials coming up that he directly attributes to this dynamic.
So his complaint isn't people are representing themselves. It's AI is telling people their case is stronger than it is.
That's his framing, yes. That AI tends to validate whatever the person tells it, rather than giving them a realistic, dispassionate assessment of their prospects. A human lawyer might say, look, this is a tough case, here's why, let's talk settlement. An AI tool, prompted by someone who's understandably upset about losing their job, tends to agree with them and help them build a case, whether or not it's actually strong.
Okay, that tracks with things I've heard elsewhere. AI as a bit of a yes man.
Right, so the proposed fix has 2 parts, and this is where it gets contentious. First, he wants the cost rules changed so that if someone runs an AI-assisted claim that fails, or never had a reasonable prospect of succeeding, the other side can actually get a costs order against them. Right now, the cost protections in this jurisdiction make that very hard to do.
And I can already hear the pushback on that one.
Go on.
Well, the people using AI to draft their own claims are, by definition, mostly people who couldn't afford a lawyer in the first place. So if you make it easier to hit them with a costs order, aren't you just adding financial risk on top of people who already didn't have the money for proper advice?
That's the central tension. And to be fair to him, he doesn't stop at the costs order. The second part of the proposal is to expand legal aid into workplace matters, the same way it already exists for family law and criminal law. So people in this position could actually get a real lawyer rather than relying on a chatbot.
Okay, that sounds like a more balanced pitch than I expected. Stick and carrot.
It sounds balanced until you actually look at the state of the carrot. Legal aid and community legal centres have been going backwards on funding for years now. Per person, it's well down on where it sat a few decades ago. And community legal centres nationally are already turning away well over 1,000 people a day because they simply don't have the capacity to help them.
Hang on, 1,000 people a day turned away before we've added a single new workplace claim to the pile?
Before a single one. And it's not a static problem either, it's getting worse. Legal Aid New South Wales has recently had to actually pull back what it can take on, including certain family law matters, unless you meet fairly narrow criteria.
So this proposal is asking an already overloaded system to take on an entirely new category of work, workplace claims, on top of matters it's already turning people away from.
That's exactly it. Which means, as it stands, expand legal aid to workplace matters isn't a funded, ready-to-go alternative to the costs order. It's an aspiration. And without new, genuine funding attached to it, it's fair to call it the weaker half of the proposal, not an equal and opposite one.
So it's less stick and carrot, more stick and a carrot someone's promised to grow eventually.
That's a fair way to put it. And it's worth being clear-eyed about where all of this actually stands right now. None of it is current law. The cost protections in the Fair Work jurisdiction haven't changed, and there's no new legal aid funding on the table to match the proposal. This is one practitioner's public advocacy for reform, a stick with a real, specific mechanism behind it, and a carrot that, on the current funding settings, doesn't really exist yet.
Good, because for a second there, I thought we needed to redraft some advice.
Not yet, but it's a genuine signal of where the debate is heading, and it connects directly to that first story. Both are really about the same underlying problem. Tribunals and practitioners figuring out, in real time, what to do when AI shows up as an uninvited third participant in a workplace dispute.
Okay, hold that thought, because here's the third thing, and it genuinely complicates everything we've just said.
Go on.
The Fair Work Commission has just handed down the first ever successful decision under the casual conversion laws. They've been in force for about 2 years, and nobody had actually won one until now. And the person who won it was entirely self-represented, using AI to run his whole case.
Wait, so the AI equals sloppy self-represented claim story we've just spent 10 minutes on, this is basically the opposite of that.
Almost point for point. A Macquarie University computing academic, casual since 2023, gave the university formal notice that he no longer met the legal test for casual employment and wanted to move to part-time. The university knocked it back. It went to arbitration and, representing himself, no lawyer at all, he beat the university's own legal team, including a barrister.
And the commission actually agreed with him?
On the legal point, yes. And that's the genuinely significant bit. The commissioner found he didn't meet the definition of a casual employee under the new test, which is the first time that test has been successfully applied since it came in. Worth being precise on the order, though, it wasn't some big permanent role. Both sides ended up agreeing on a fairly modest fraction of full-time hours, averaged out over the year. So the landmark part is the legal finding, that he wasn't really casual and could force the conversion, not the size of what he actually won.
Okay, and where does the AI actually come into this? Because I want to be careful here. Did the commissioner rely on AI-generated argument? Or is this more, a guy used AI to prepare well?
That's an important distinction, and it's worth being precise about, because the written decision itself doesn't mention AI anywhere. It's entirely legal reasoning about the statutory test. The AI story comes entirely from what he told a journalist afterwards. He says he used paid, professional-grade AI tools rather than free ones, uploaded all his case material, and had the tools cross-check every citation and stress-test his arguments the night before the hearing.
So AI didn't stand up and argue the case. He did, using AI as research and preparation.
Exactly. He's the one who appeared and argued it. But he's also on record saying it demolished the university's arguments, and to his credit, he disclosed to the commission at the time that he was using AI.
That disclosure point actually matters a lot, given everything we've just said about undisclosed AI-drafted correspondence. This is the version of AI-assisted self-representation done properly, disclosed, quality-checked, prepared with genuinely sophisticated tools.
Which is also the catch. He's not a typical self-represented litigant. He's a computing and AI specialist, paying real money for premium tools who knew exactly how to direct them. Most people going up against an employer with AI help are using free tools with none of that rigor, which is precisely the AI slop problem we spent the last segment on.
So this isn't proof AI is quietly leveling the playing field for the average self-represented person, yet. It's proof of what's possible when someone genuinely knows what they're doing with it.
Right, but that's exactly why it's worth watching closely. If a well-resourced, disclosed, properly quality-controlled version of this can already beat an experienced legal team and a barrister, the gap between AI slop and AI done well is the whole story for where this heads next.
Which is a good note to head into takeaways on. This case doesn't cancel out anything else we've said today. It sharpens it.
So let's get practical. If someone's listening to this thinking, okay, what do I actually do differently on Monday? What have you got?
2 things. First, treat AI drafted material in a live dispute as a live risk, not just a style issue. If you're advising a client or reviewing correspondence going out under your firm's name, and it reads like it's been run through a chatbot, overly long, repetitive, heavy on generalizations, accusatory in tone, flag it. Not just because it reads badly, but because we now have a tribunal on the record treating that kind of correspondence as something worth actively curbing. That's a precedent in waiting, even if it's not binding yet.
So basically, if it reads like a chatbot wrote it, assume a decision maker will notice and it won't help your client.
Exactly. Second takeaway. Stop assuming a self-represented, AI-assisted opposing party means a weak case you can steamroll. The numbers we just talked about say this is now a normal fact pattern, not an edge case. That means factoring early, realistic settlement conversations into your strategy from the outset, rather than assuming the other side's AI-generated claim will just collapse under its own weight. Sometimes it will. Increasingly, it drags on regardless because nobody on the other side has had a frank conversation with them about their actual prospects.
Which, ironically, is the access to justice gap he was talking about. Nobody's had that frank conversation because they couldn't afford one.
Which is exactly why this is worth watching rather than dismissing. Whatever you think of the penalise them half of his proposal, the underlying diagnosis, that a lot of these litigants have nobody giving them a reality check, is hard to argue with.
Is there a middle ground practical step here, short of waiting for legislation to catch up?
Honestly, yes, and it costs nothing to implement. If you're on the receiving end of an AI-drafted claim, an early, plainly worded letter that sets out the actual legal test and the genuine risks of running the matter to trial can do a lot of the work a lawyer would otherwise have done for that person. It's not a substitute for legal aid, but it at least injects one dose of reality into a process that might otherwise run entirely on AI-generated confidence.
So instead of just defending the claim, you're also almost doing a bit of the reality check role that's missing.
In a limited, appropriate way, yes. It won't work every time. Some people will run the case regardless. But it costs you a letter and it might save everyone a trial.
Given the Macquarie case, is there a third takeaway hiding in there too?
There is, and it's the corrective to assuming every self-represented, AI-assisted opponent is weak. Don't judge the quality of an AI-assisted claim by the fact that AI was involved. Judge it on the actual arguments and evidence in front of you. The gap between a sloppy, free-tool claim and a properly prepared one can be enormous, and this case shows the properly prepared end of that spectrum can already beat experienced lawyers outright.
So, check the quality before you judge the source.
Exactly that.
All right, so to wrap this one up, a tribunal has made an order banning AI from party correspondence in a live dispute, even though nobody's quite sure how you enforce that. A defense-side lawyer is publicly pushing for costs penalties on failed AI-assisted claims, paired with a call for more legal aid that the current funding settings can't actually support yet. And now we've also got the first successful casual conversion case under the new laws, won by a self-represented litigant who beat an experienced legal team using disclosed, properly quality-checked AI tools.
And the through line for anyone practicing in this space is AI isn't a future problem in workplace disputes anymore. It's an active fact pattern on every side of the table, sometimes producing exactly the sloppy mess we've been warning about, and sometimes producing a genuinely well-run case that beats experienced lawyers outright. It's already shaping remedies, reform proposals, and outcomes in real time.
Definitely one to keep an eye on rather than file away.
Agreed. Well, thanks for listening. We'll be back with the next development as it lands.
See you next time. That's it for today's episode on LexiCast. If you're looking for more in-depth episodes that can also be claimed as CPD activities, check out our LexiCast CPD page, linked in the show notes. Follow us now to stay up to date. We'll see you next time.